I was refinancing my mortgage, which meant pulling a fresh copy of my recorded deed from the county for the closing paperwork. A routine task I've done 100 times for other people in my professional life, without ever once expecting to find anything unusual in my own file. I remember sitting at my kitchen table with that document in front of me, scanning it out of habit more than genuine concern, when my eyes landed on a name added to the property record that had absolutely no business being there. My name is Harlan Boyce. I'm 49 years old, and I've worked as a commissioned notary public for the better part of 22 years, the last 14 of those running my own independent notary and document authentication service out of a small office attached to my house. I spend my working days verifying signatures, confirming identities, and spotting the kind of small, telling inconsistencies that separate a genuine document from a forged one. A skill set that becomes almost involuntary after enough years in the profession. You start noticing things other people simply wouldn't think to look for. The pressure of a pen stroke, the spacing between a signature and a notary seal, the subtle differences between a signature made in one sitting and one added later by a different hand entirely. That skill set is exactly what saved me the day I found Marilee Thaxton's name quietly attached to a recorded easement modification on my own property deed. An amendment I had never signed, never authorized, and never even heard about until the moment I saw it sitting there in black and white. I bought my house 6 years ago, a modest 3-bedroom place on a half-acre lot in a community called Ferngate Crossing, and I want to explain something about the property itself before I go any further, because it matters a great deal to everything that followed. My lot includes a narrow strip of land along the back boundary, roughly 15 feet wide, that runs behind 3 neighboring properties before connecting to a small stormwater detention area the county requires every subdivision of a certain size to maintain. That strip has always belonged entirely to me, clearly marked on my original survey and recorded deed, though the Ferngate Crossing Homeowners Association had, for as long as I'd lived there, informally treated it as part of a walking path connecting several streets, an arrangement I never objected to since it never caused me any actual inconvenience. Marilee Thaxton had served as president of the Ferngate Crossing Homeowners Association for just over 2 years, by the time I sat down at my kitchen table that afternoon with my freshly pulled deed. I'd exchanged pleasant enough small talk with her at community events over the years, nothing more memorable than that, and I had absolutely no reason, walking into that refinancing appointment, to expect I'd find anything remotely unusual waiting for me in my own property records. What I found was a recorded easement amendment, filed roughly 8 months earlier, granting the Ferngate Crossing Homeowners Association what the document called a permanent maintenance and improvement easement over that 15-foot strip along my back boundary, effectively transferring meaningful control over a portion of my own property to the association, permanently, without my ever having agreed to any such thing. At the bottom of that amendment sat a signature purporting to be mine, along with a notary seal and signature belonging to a notary I had never once met, working out of an office roughly 40 miles from my house. I want to walk through exactly what I noticed first, because it's the same methodical process I use every single day in my professional work, and it's precisely what allowed me to recognize the forgery within about 30 seconds of actually looking closely at that signature, rather than simply skimming past it the way most homeowners understandably would. The signature itself was close, I'll grant it that much. Whoever produced it had clearly studied an authentic sample of my handwriting, likely something as simple as a signed HOA newsletter acknowledgement or a package delivery confirmation, both of which I'd signed dozens of times over the years without ever imagining either document might someday serve as a template for forgery. But 22 years of professional practice teaches you that a traced or carefully copied signature almost always carries certain telltale signs a casual observer would never notice. The pen pressure in my genuine signature varies naturally throughout the stroke, heavier at the start of each letter and lightening as my hand moves across the page. a pattern built from decades of writing my own name the same way without ever thinking about it. The signature on that easement amendment showed almost perfectly uniform pressure throughout. The unmistakable signature of someone moving slowly and deliberately to copy an existing sample rather than someone signing naturally and quickly the way a person does with their own name. More damning still, to my professional eye, was the notary seal itself. I know the visual conventions of legitimate notary stamps better than almost anyone, having ordered and used a half-dozen of my own over the years as equipment wore out or commission renewals required updated seals. The seal on that document was slightly, almost imperceptibly, too crisp, too perfectly centered. The kind of clean impression you get from a fresh, unused stamp rather than one that's seen the wear of regular daily use. And the notary's registered commission number. When I quietly checked it against the state's public notary registry that same evening, returned no active record at all. Whoever that name and number belonged to, if they existed at all, had never held an active commission in the state. I want to be honest that my first instinct, sitting there at my kitchen table with a forged signature staring back at me from my own property records, was a strange kind of professional offense that ran even deeper than the more obvious anger over losing partial control of my own land. I've spent 22 years building a career around the principle that a properly notarized document means something, that the seal and signature attached to it represent a genuine, verified act, rather than a convenient fiction manufactured to make an unauthorized transaction look legitimate. Finding a fabricated notarization sitting in my own county's official records felt, in a strange way, like a personal violation of everything I'd built my professional life around. I called an attorney the following morning, a careful, detail-oriented woman named Perpetua Sandoval, who'd handled property fraud cases throughout the county for nearly 15 years. I laid out everything, the easement amendment, the signature analysis, the non-existent notary commission, and she listened without interrupting, the way good attorneys tend to do, taking careful notes the entire time. "This is about as clean a forgery case as I've encountered," Perpetua told me once I'd finished. "Most fraudulent easement claims I see involve genuine ambiguity, an old boundary dispute, or a misunderstood agreement from decades earlier. What you're describing, a fabricated signature paired with a notary commission that doesn't even exist in the state registry, isn't ambiguous at all. That's straightforward, provable fraud." She asked me to formally document everything I'd identified professionally, treating my own analysis with the same rigor I'd apply to any authentication dispute brought to my office by a client, and to prepare a written statement detailing exactly what markers had led me to identify the signature and seal as fraudulent. I drove to the county recorder's office that same week and requested the complete filing history for the easement amendment, hoping to trace exactly who had submitted it and when. A records clerk named Doreen Ashworth, a patient woman who'd worked in that office for longer than I'd lived in Ferngate Crossing, pulled the full submission file for me, including the cover sheet identifying who had physically filed the document with the county. The filing had been submitted by a paralegal service, the Ferngate Crossing Homeowners Association, regularly used for routine association filings. A small local firm that handled straightforward administrative paperwork like lien releases and minor bylaws amendments. Not the kind of firm typically involved in complex property transfers requiring genuine homeowner signatures. Whoever filed this, Doreen told me, would have submitted it along with whatever supporting documentation the county requires for an easement amendment, which in this case just means the signed and notarized document itself. We don't independently verify signatures at intake. We rely on the notarization to certify that the signing actually occurred as represented. That explained, in practical terms, exactly how a fabricated document with a fake notary seal could slip through county recording without anyone catching it at the point of filing. The entire recording system depends on the good faith assumption that a notary seal represents a genuine, verified signing event. Precisely the assumption that whoever created this document had exploited by fabricating a non-existent notary commission, rather than risk having a real notary refuse to certify a signature they hadn't actually witnessed. Perpetua's investigator spent the following 2 weeks tracing the paralegal service's own records, working through a formal document request that the firm, once they understood the seriousness of what was being alleged, cooperated with fairly readily, apparently having no idea themselves that the document they'd filed on the association's behalf contained a fabricated signature and notarization. What emerged was a timeline that placed the actual creation of the forged documents squarely within Marilee Thaxton's own home office computer. Based on metadata the investigator recovered from the digital file, the paralegal service had received via email from Marilee's own association account, showing the document had been created and edited using software registered to her personal computer roughly 3 days before it was sent to the paralegal firm for filing. I want to be fair and note that metadata alone, while highly suggestive, isn't necessarily conclusive proof of exactly who typed a document or affixed a fabricated signature, and Perpetua was careful to build the case on more than that single piece of evidence. But combined with everything else, the non-existent notary commission, my own professional signature analysis, and the fact that the easement amendment conveniently benefited the association Marilee personally led, the picture that emerged left very little room for innocent explanation. The most significant piece of corroborating evidence, as it turned out, came from a neighbor of mine named Cassius Delgado, who lived on the adjacent property that also bordered the disputed 15-foot strip. Cassius mentioned to me, once word of the situation began circulating through the neighborhood, that Marilee had approached him roughly a year earlier asking whether he'd be willing to sign a similar easement amendment covering the portion of that same strip running behind his own property. I told her I'd need to review it with my own attorney first, Cassius said, since I wasn't clear on why the association suddenly needed a permanent maintenance easement over land we already let people walk through informally without any trouble. She seemed frustrated by that, told me it was really just a formality, but backed off when I said I wanted my lawyer to look at it. Cassius had never signed anything, which meant the amendment covering his portion of that strip had never been filed. But his account confirmed that Marilee had, at minimum, been actively pursuing a broader plan to formalize the association's control over that entire boundary strip well before my own forged amendment ever appeared in the county records, and that she'd encountered at least one homeowner unwilling to simply sign without question. I found myself wondering, once Cassius told me this, whether she had approached me directly at some point and simply given up when I wasn't home, deciding it was easier to fabricate my signature entirely than risk another homeowner asking the same uncomfortable questions Cassius had raised. The Ferngate Crossing Board held its next scheduled meeting about 6 weeks after I first discovered the forged amendment, and by that point, word of the situation had circulated widely enough through the neighborhood that the community room was considerably fuller than I understood these meetings typically ran. I attended alongside Perpetua, along with Cassius, who'd offered to describe his own earlier encounter with Marilee's proposal. Marilee opened the meeting attempting to characterize the entire situation as a misunderstanding involving an association paralegal service that had apparently filed paperwork prematurely, before proper homeowner signatures had been fully secured, language carefully chosen to shift responsibility toward the filing firm rather than acknowledge the forged signature sitting at the center of the entire matter. I want to describe the moment that changed the room's understanding entirely, because it happened faster and more decisively than I'd expected. Perpetua stood, presented a large printed comparison of my genuine signature alongside the forged one from the easement amendment, and asked me, as the notary and authentication professional present, to walk the board through exactly what I'd identified. I kept my explanation as plain and unemotional as I could manage, describing the uniform pen pressure, the telltale signs of a traced rather than natural signature, and the notary commission number that returned no record whatsoever in the state's public registry. I watched several board members lean forward to examine the documents themselves, and I watched Marilee's composure begin to visibly falter as the room's attention shifted from her explanation toward the physical evidence sitting on the table in front of them. A board member named Rosalind Chterberg, who'd served alongside Marilee for over a year and had, by her own later admission, always found her a diligent and effective association leader, asked the question that seemed to finally settle the matter beyond any further doubt. "Marilee," she said, "can you explain why the digital file containing this document was created on your own home computer 3 days before it was sent to the paralegal firm for filing?" Marilee didn't have an answer that satisfied anyone in that room, and the silence that followed her attempt to explain it away told its own story just as clearly as Cordelia Vance's silence had told a story in an entirely different HOA meeting months earlier. The particular silence of someone who has run out of plausible explanations and knows it. The board voted that same night to formally rescind the easement amendment and refer the entire matter to the county recorder's office and local law enforcement for further investigation into the fabricated notarization. A serious matter, given that filing a document with a fraudulent notary seal carries meaningful criminal exposure separate from any civil dispute over the property itself. Marilee resigned from the board within days, before the vote to formally remove her had even been scheduled, and Rosalind stepped in as interim president, one of her first actions being a full audit of every filing the association had submitted through that same paralegal service over the previous 2 years, to confirm nothing else had slipped through with a similarly fabricated signature attached to it. I want to be clear that the audit turned up nothing else quite so serious, which suggested this had been an isolated act rather than an established pattern, the way Deandra Wexler's master key abuse had turned out to be in an entirely different neighborhood. But isolated or not, the seriousness of fabricating both a homeowner's signature and an entire notary commission that never existed struck everyone involved, myself especially, as considerably more troubling than an ordinary boundary dispute or an overzealous interpretation of association authority. My property record now reflects exactly what it always should have: the 15-foot strip along my back boundary belonging entirely to me, with no easement amendment attached to it at all. And the county recorder's office has since updated their intake procedures for any filing purporting to convey easement rights, requiring additional identity verification for the underlying signatures whenever an association or third party submits paperwork on a homeowner's behalf rather than the homeowner filing directly themselves. I still get the occasional client at my own notary office who jokes that I must be impossible to fool given what happened with my own deed, and I usually just smile and tell them that 22 years in this profession teaches you to notice things most people never think to look for, whether that's a client's signature sitting in front of me or a forged one sitting quietly in my own county's official records, waiting patiently for exactly the wrong person to finally sit down and actually look closely at it. If this story hit home for you, do me a favor and hit that like button. It genuinely helps this channel keep growing. And if you haven't already, go ahead and subscribe so you don't miss the next one, because there are plenty more stories just like this one still to come. Drop a comment down below and let me know what you thought of this one, or whether you've ever found something in your own paperwork that didn't quite look right once you actually stopped to examine it closely. I read every single comment, and honestly, some of the best stories on this channel started as a comment somebody left on a video just like this.